The remedies problem from February of 1988 mostly is a torts problem, but you'll see there also are contracts issues present and remedies, particularly damages. So this question is very instructive because it helps us to see how the civil remedies subjects are tested at the same time. Take a look at the call of the question, and we see a four-part call, which makes a fair amount of sense on its face. 1. The 2-year statute of limitations for tort actions bars the suit. We'll examine the facts and the dates, we'll check out the statute of limitations, we'll apply the law to the facts, and we'll reach a conclusion. 2. The complaint fails to state a cause of action in tort. Well, here we're going to go fishing for tort theories of liability, and we'll present as many of them as we can. 3. The complaint fails to state a cause of action under any other legal theory. Okay, what they mean here is any other testable subject. If torts is covered in the second call, the third call is looking at other theories of liability from different subjects. The most common would be contracts, and it turns out that's what's present here. Then call of the question 4. Even if the complaint states a cause of action, the damages sought can't be recovered under any theory suggested by the facts alleged. So here we compare contracts and torts damages, presumably, and we see whether or not the results are the same or different with either. Probably the issue will boil down to one of foreseeability. Okay, a four-part call of the question. That makes this a relatively easy problem because we don't have to figure out so much, we just have to answer 4 short questions. Take a look at the top of the question, and we'll see that the facts of this problem are relatively uncomplicated. Our plaintiff is Prof. He agreed to deliver a lecture at State College on January 10, 1985 for a $10,000 fee. On January 31, he goes to Flywright to, turns out they're the defendant, and he asks about flights to State College. He tells a Flywright employee that he has to be at State College by 3 p.m. When told that Midwest Flight 1, which left at noon, would get him to State College by 1:30, he purchased a reserve seat, non-refundable, super discount ticket on that flight. The ticket, prepared by the Flywright employee, bore both the flight number and the departure time stated by the Flywright employee. Okay, so far so good. We've got a professor who's been hired to give a lecture. He goes to get a plane ticket to make sure he can get to that lecture. So far so good. So far, no torts or breaches have occurred. Paragraph 2. Prof arrived at the airport at 11:30 a.m. on January 10, ample time to check in and pass through security at that airport, but discovered that the flight had left at 11:25, in conformity with a new schedule that had been sent on December 1. Notice he got his ticket on December 31. That shows that Flywright has engaged in an act of negligence. We find out why. They had been notified on December 1, had received the new schedule on December 5, and had not updated its computer. No alternative transportation was available. Prof didn't get to deliver his lecture. So he had to return a $5,000 advance, and he didn't get to earn the full $10,000 lecture fee. That goes to his damages. And the question presented is, are these damages foreseeable? Now let's pause for a moment and think for a moment about the third call of the question. Are there other theories of liability? Sure, his purchase of that ticket is a contract, and their failure to give him a valid ticket is a breach of contract. So this damages issue boils down to one of foreseeability. It's a consequential damage in breach of contract. So we'll examine that below. In paragraph 3, we've got a lawsuit filed January 5th between Prof and Flywright for damages. He alleges that damages were incurred because Flywright's negligence made it impossible for him to deliver his lecture and therefore cost him the lecture fee and the cost of the ticket. He also seeks punitive damages. Okay, wait a second. We know that punitive damages are not available to plaintiffs who successfully plead negligence. You've got to have more than mere negligence to be entitled to punitive damages. Now we find fly right seeking dismissal of the complaint by a procedurally proper motion claiming, and then we get the four-part call of the question. In my judgment, this is a straightforward problem with one wrinkle, and that wrinkle is the third call of the question. You've got to be savvy to the fact that once we eliminate torts, as we do in the second question, that leaves us with the remaining testable subjects as the source of other theories of liability, here clearly contracts. So have a look now at the outline of issues that I present, and here I think you'll see it's possible to organize a very thoughtful response in a fair amount of detail without doing anything counterintuitive. Have a look at the first set of analysis with regard to the statute of limitations. The issue is, when does the statute begin to run? On the date of the purchase or the date of the injury? I think there's a pretty clear correct answer to this question. The statute will start running on the date of the injury. Therefore, the statute of limitations will not bar this suit. Next, does the complaint state a cause of action in tort? Well, we're told that the plaintiff is seeking to recover for negligence. I add a word to that and consider it a cause of action for negligent misrepresentation. So we've got a material misrepresentation of fact with regard to the time of the flight. We've got a vicarious liability issue because we're seeking to bind an employer for liability of the acts of the employee, and then we consider negligence, duty, breach, causation, damages, subject to defenses. And the defenses are contributory and comparative fault. I'll tell you what, if anybody offers me $10,000 to go deliver a one-day lecture, you can be well assured that I will be calling the airport every 15 or 20 minutes for the last week before the flight takes off, just to make sure I'm going to be on that flight. Now, I have one line item of analysis with regard to punitive damages. The misrepresentation would have to be fraudulent in order for punitive damages to be available. They're not available for merely negligent misrepresentations. So I reach a conclusion with regard to the entire body of analysis. Next, we turn to the other possible legal theory, here the breach of contract. We spend a little bit of time on formation and performance, and breach, we reach a conclusion. Next, we turn to damages. I have a separate section, each for tort damages and contract damages. I talk about compensatory and punitive damages underneath each one of them. Okay, now let's consider an answer to this problem, and the lesson that we will learn is civil remedies is one big topic. It's a little arbitrary to break it down amongst torts, contracts, real property, corporations, etc. Anytime we've got civil litigants, remedies is likely to be at issue, and the theory of liability will be important too. So first we focus on the statute of limitations in my answer. And here you'll see my analysis is very centered on the facts. The bottom line is this lawsuit was timely filed, the motion should be denied. Next we consider whether or not the complaint states a cause of action in torts. I focus on negligent misrepresentation. I lead with the facts. Then I go into the elements of liability. I focus on the material misrepresentation and the vicarious liability. You'll notice that I don't recite a lot of law here. If you spent time to carefully define every legal principle presented by this complicated question, you would have time for no analysis. I think you'll agree the structure of this answer reflects a fairly sophisticated understanding of the law. We're not going to be worried about reciting long definitions anywhere, and certainly not in an answer to this question. Next, I focus on the actual negligence. And here you'll see I don't break it down internally as to elements. I squish it all together because I think it makes the analysis flow better, and I think it makes it easier to read. I focus on reliance, and I conclude that the plaintiff has stated a valid cause of action for negligent misrepresentation in jurisdictions that allow that cause of action. Then I focus on the defense of contributory and comparative fault. It isn't dispositive as to the case, but I do spend a little time on it, and I indicate that the professor certainly is not blameless. He didn't miss this flight without making mistakes himself. Briefly, I touch on intentional misrepresentation to distinguish it from the current case, and then I reach a conclusion. the professor has stated a valid negligence claim, the motion to dismiss is best denied. Next, we turn to the breach of contract theory, and here you'll notice I don't really go into a lot of depth. Why? Because there isn't a lot of depth to go into. When we get to contracts, you'll see there is lots of elaborate issues about formation, about breach, and about remedies. Here we are on a relative bunny slope in terms of the degree of difficulty. All we're being asked here is to spot the theory and basically tip our hat to it. It seems to me the professor also has an entirely valid cause of action for breach of contract. And that's another good reason for the court to deny the motion to dismiss. Then, finally, we focus on the damages issue. And here, the tort damages are the more elaborate issues presented. As I say, this is basically a torts question. The elements of contracts and remedies are present too. So the issue here is, what damages can the professor recover? The real issue is, can he recover for his lecture fee? And I say it depends on the foreseeability of those losses to Flyride. And it seems to me a very close call. I say it's possible that he will be able to recover the lecture fee subject to the contributory or comparative negligence defense. I also argue that punitive damages are unavailable because this plaintiff only has established negligence. He has not shown recklessness or some intentionally tortious misconduct, so no punitive damages. Then I focus on contracts damages, and here I think we're able to reach a somewhat more clear answer about the lecture fee. I find that damage to be unrecoverable under the contracts theory because of the lack of knowledge that the defendant had as to these consequential damages. As we'll see, consequential damages have to be foreseeable to the breaching party at the time the contract was formed. So I guess anytime I get hired to deliver a lecture with an extensive fee, I should brag about that to the people that sell me the ticket.